The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Surviving Spouses' Rights in Illinois Probate, Take 3. Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to talk about the surviving spouse's rights in an Illinois probate case. We'll discuss the difference between a surviving spouse's award and the surviving spouse's right to renounce the will, and then we'll discuss which one is preferable based on the circumstances. First, let's talk about the surviving spouse's award. So a surviving spouse, when their spouse passes away, is entitled to an award from their deceased spouse's estate in an amount that is reasonable, according to the court, to support the surviving spouse for 9 months after the death of their spouse. The minimum amount of this award, assuming the estate has enough money in it, is $20,000, but the surviving spouse can petition the court for a higher amount based on his or her standard of living during the marriage. Now, importantly, a surviving spouse's award is a second-class claim. That sounds bad, but it's actually really good. First-class claims are funeral and related expenses, and those come out of the estate before a surviving spouse's award, but a surviving spouse's award comes next after that, before taxes and creditors. So if there's $25,000 in the estate, and there's, after funeral expenses, and there's $10,000 owed in taxes and creditors, well, tough luck for the taxes and creditors. The surviving spouse is going to get his or her minimum of $20,000, and whatever is left will go to the taxes and creditors. So that's important to know. The surviving spouse's award, the key feature is that it's a really high-class claim and comes out early in an estate. It can be taken in goods and chattels, which means that the surviving spouse can basically provide a list of personal physical property that he or she would like instead of money as part of the award. It's not discretionary, so that means regardless of whether the spouse was estranged from the deceased or there were other factors that would make it so that you think, well, maybe the deceased person wouldn't want the spouse to get this award, the court is required to give this award regardless, unless the will explicitly states that the surviving spouse is not to receive the surviving spouse's award. That's the one situation where the surviving spouse wouldn't get this award, or if the estate doesn't have enough money in it after funeral expenses to cover the amount of the award. Now let's discuss the right to renounce the will of the surviving spouse. So the surviving spouse, if he or she doesn't like what is left to them in the deceased person's will, has the right to renounce it. And the way this works is they have to file a filing with the court within 7 months of the date of the will being admitted into probate, indicating their intention to exercise this right. If they exercise this right, they get a half share of the estate if there are no surviving descendants of the deceased person. If there are surviving descendants of the deceased person, they get a 1/3 share of the estate. So if the will leaves them more than this, they're obviously not going to want to renounce it. But if the will leaves them less than half or a third, depending on the situation, then they can say, well, that's not good enough. I want to renounce the will and get that. Now, the will is still effective as to everybody else. It's just the surviving spouse's share will come out first, then anything that's left over is distributed to the other beneficiaries of the will, as if the surviving spouse had predeceased the deceased individual. So if the will leaves the surviving spouse 10% and he or she renounces the will and gets 33%, they don't also get the 10% that the will left them. That kind of goes into the estate as if they were not part of the estate. What's important here is that this is classed after taxes and creditors. So what that means is that while the surviving spouse's award comes out right after funeral expenses, this is after all the bills are paid. Whatever is left, the surviving spouse gets their share. So what's really important here is there's two factors that you have to figure out in order to determine whether to exercise the surviving spouse's award or to renounce the will. One is the size of the estate, and it's basically, are you going to get more than $20,000 if you take half or a third of the estate or whatever your surviving spouse's award is. If you are, then you should renounce the will rather than exercising the surviving spouse's award. If the estate is small, or if there's a lot of creditors, and after creditors you wouldn't get more than $20,000, then you're probably going to want to exercise the surviving spouse's award rather than renouncing the will, because that can be 100% of the estate as opposed to half or 1/3. So it really depends on the size of the estate and whether whether there's creditors or taxes playing a factor that you want to jump ahead of when exercising this award. The other thing I'll briefly mention is that unlike renouncing a will, which requires a filing with the court, the surviving spouse's award is automatic. So you don't have to file anything with the court unless you want to basically work your way up above the $20,000 minimum. Finally, if there's a prenuptial agreement in play, it will always control. So the same way I said you could explicitly write somebody out of the will and they wouldn't get the surviving spouse's award, if the prenuptial agreement says that you're not going to get anything from my estate, then that will trump the surviving spouse's award and the right to renounce the will. So if you have any questions, feel free to leave them below this post in the comments section at learn-about-law.com. We try to get you an answer within a couple of days. You can also leave them below the YouTube video on our YouTube station. If you found this helpful and would like to be informed about our daily article and video topics that we post, you can subscribe to us at YouTube, iTunes, and SoundCloud, or submit your email to be part of our email blast that we send out once a month at learn-about-law.com. If you need some help, give us a call at 630-324-6666. That's 630-324-6666. We have for free consultations, and we have offices all around Chicagoland for your convenience. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.